Hello and welcome. Today I will explore the evolution of special education in the United States, tracing its progression from a history of neglect and exclusion to the robust legal protections that are in place today. I will conclude with resources that can assist educators in staying informed about current legal trends. Now, before the 1970s, many children with disabilities were systematically denied access to public education. Public schools frequently refused to enroll these students, arguing that they could not accommodate their needs. Others were placed in separate institutions that offered minimal instruction and care. At that time, no federal laws existed to guarantee educational access or rights for students with disabilities, leaving education for these individuals largely dependent on family resources, local advocacy, or charitable organizations. The civil rights movement of the 50s and 60s significantly transformed the educational landscape in the United States. The Supreme Court's landmark decision in Brown v. Board of Education in 1954 asserted that separate is inherently unequal. While this ruling specifically addressed racial segregation, it laid the groundwork for a broader constitutional principle. All students are entitled to equal educational opportunities, irrespective of their background or their characteristics. The early 70s heralded the advent of modern special education law, marked by two pivotal court cases that reshaped the special educational law in the United States. Pennsylvania Association for Retarded Children versus Commonwealth of Pennsylvania in 1972. The court concluded that students with intellectual disabilities possess a constitutional right to a free public education, requiring schools to implement programs tailored to their individual needs. Mills versus Board of Education of the District of Columbia. This case broadened those rights to encompass all children with disabilities, emphasizing that insufficient funding could not serve as a justification for denying a child's right to education. The cases in question significantly influenced Congress to enact Public Law 94-142 in 1975. It is known as the Education for All Handicapped Children Act. This legislation established the foundation for what we now refer to as the Individuals with Disabilities Education Act, otherwise known as the IDEA. Under the IDEA, schools are obligated to provide a free, appropriate public education where every child with a disability is entitled to receive special education and related services at no cost to parents. These services are designed to address their unique needs and prepare them for future education, employment, and independent living. Additionally, an individualized education program, or IEP, for each eligible student. Each student must have a written IEP developed by a collaborative team that involves the parents, teachers, and specialists. This document outlines the child's current performance levels, sets goals, identified services, necessary accommodations, and methods for measuring their progress. Next, placement in the least restrictive environment, or LRE. Students with disabilities should be educated alongside their non-disabled peers to the greatest extent appropriate. Removal from the general education setting should only occur if the nature or severity of the disability hinders satisfactory education, even with available supports and services. Lastly, due process protections for parents and students. The IDEA ensures procedural safeguards that protect the rights of children with disabilities and their families, which include notification, access to educational records, mediation, impartial hearings, and the right to appeal decisions. In 1990, Congress passed the Americans with Disability Act, the ADA, which extended disability rights from schools to workplaces, public facilities, and transportation. Recently, the case of Andrew F. versus Douglas County School District in 2017 elevated the standards from what constitutes an appropriate education. The Supreme Court determined that an individualized education program must be appropriately ambitious in light of the child's circumstances, mandating that schools provide opportunities for meaningful progress instead of merely delivering minimal benefits. In addition to these significant rulings, federal laws have bolstered the rights of parents and students, ensuring transparency, privacy, and active involvement in educational decisions. Concerning parental rights under the Individuals with Disabilities Education Act, the case of Schaefer versus Wiest, 2005, examined the burden of proof in situations where a parent contests an individualized education program. The ruling established that the party seeking the relief bears the responsibility of demonstrating that the IEP is inadequate unless a state law dictates otherwise. This case highlighted the crucial role parents play in special education process, while also clarifying the standards for due process hearings. Students with disabilities in public charter schools enjoy the same rights under the IDEA and the Americans with Disabilities Act. The same as their peers in traditional public schools. Charter schools are required to admit students with disabilities and provide appropriate services. Conversely, students in private schools experience different regulations. They are entitled to equitable services under IDEA, but they are not guaranteed a complete IEP, as private institutions are not obligated to provide a full, free, appropriate public education. As education law continues to evolve, it is essential for educators to remain informed about the latest developments in the field. Here are 4 recommended resources to help educators stay informed. The U.S. Department of Education Office of Special Education Programs. OSEP provides updates, guidance documents, and policy letters concerning IDEA and federal special education compliance. The Council for Exceptional Children. The CEC offers professional development opportunities, legal updates, webinars, and publications, such as Teaching Exceptional Children, which address current trends and court decisions relevant to special education. Rights Law. This is a reliable online resource for educators and parents. Rights Law delivers clear explanations of legal rights under IDEA, Section 504, and the ADA, along with summaries of recent court cases and due process hearings. Lastly, the Illinois State Board of Education. This Illinois-specific resource offers guidance on implementing the IDEA, updates on state regulations, and professional developmental opportunities as well. ISBE also publishes bulletins that detail current legal rulings, compliance expectations, and procedural safeguards for educators and families in Illinois. By utilizing these resources, teachers can easily stay informed, ethically grounded, and prepare to advocate for their students' rights. The history of special education showcases remarkable progress, transitioning from exclusion to inclusion and from silence to advocacy. Landmark cases such as PARC versus Pennsylvania, Mills versus Board of Education, and Andrew F. versus Douglas County have redefined the notion of a free, appropriate public education. Legislation like FERPA and IDEA has empowered parents and students to claim their educational rights. As educators, it is crucial to remain informed through reputable sources such as CEC, Rights Law, and the Illinois State Board of Education. This knowledge not only deepens our understanding of the law, but also enables us to uphold its spirit, creating an environment where every learner has the opportunity to thrive. Thank you, and I hope that you did learn something today.